Okay, going to read about issue preclusion from the top, also referred to as collateral estoppel. Refers to the preclusive effect that prior judicial determinations have on the relitigation of certain issues rather than claims. Classically speaking, to invoke the doctrine of issue preclusion, 1, the issue to be precluded and subsequent litigation must be the same issue that was raised in the prior litigation that resulted in a final judgment. So that's the first factor. 2, the issue must have been actually litigated and determined in the first case. 3, resolution of that issue must have been necessary to the judgment and the initial action. And 4, the subsequent action must involve the same parties or their privities. And modern view of the doctrine embraced in the federal system and in most state jurisdictions no longer holds completely to the same parties requirement, a matter that will be taken up in the case I'm about to read. The contours of the issue preclusion doctrine, however, in several important respects from claim preclusion, but also have areas of commonality. Dealing with the common matters first, whether the parties in subsequent litigation are the same or in privity with those who were parties to prior litigation is determined according to the same principles discussed above in the context of claim preclusion. In the context, similarly, determining whether the previous action culminated in a valid final judgment is accomplished by the same analysis in both contexts. The differences between the two doctrines lie within the same issue requirement for issue preclusion. The same claim requirement for claim preclusion has been broadly conceived to encompass all transactionally related claims that could have been asserted but were not. In contrast, issue preclusion requires that the issues be identical, not merely transactionally related, and that the issues must have actually been raised and litigated. Having had the opportunity to raise an issue but failing to do so is not enough to trigger the preclusion. Thus, while there are complications to figuring out whether the same claim is involved in two successive actions arising from the need to consult the transactional test, because issue preclusion requires identical issues, whether the same issue requirement has been met will be difficult to determine. More complicated will be the effort to figure out whether the issue was actually litigated in prior suit. The further unique aspect of issue preclusion is in that requirement that the resolution of the issue in the prior action must have been necessary to the outcome of the case, another matter that can sometimes be difficult to determine. Before reading the next case, we're going to touch on the same parties requirement and non-mutuality. Only parties to a particular action or their privities may be bound by claim preclusion. I say that, but because somebody crossed out the word issue here and wrote claim in the margin. So reading that again, only parties to a prior claim or their privities may be bound by issue preclusion. So that could potentially be a book error. Anyway, does the same limitation apply to who can invoke issue preclusion? Although the classic statement of the doctrine of issue preclusion includes the idea that only parties and their privities can invoke this issue preclusion effect of a prior determination, a concept known as mutuality, it can no longer be definitively asserted that this requirement is an absolute. To the contrary, the mutuality doctrine has long been excised from the heart of the doctrine at the federal level. Initially, the rule of mutuality was thought to be necessary to achieve fairness. It did not seem fair to permit a non-party to a previous action to invoke an adverse determination on an issue in that action against a party to that action. For example, if A sued B for negligence and it was determined that the action that B was negligent for crossing a double yellow line in the street, mutuality held that in an action by C, the driver of another vehicle, against B, for negligence arising out of the same accident, C could not invoke the decision in A versus B regarding B's negligence as conclusive against B in C versus B. Thus, B would traditionally have been able to challenge C's assertions of negligence, even though B had previously done so and lost in the first action. In the next case, we review the Supreme Court's decision in which the mutuality doctrine was effectively slain in favor of non-mutuality. Parklane Hosiery Company v. Shore. 1979, heard in SCOTUS, Mr. Justice Stewart delivered the opinion of the court. This case presents the question whether a party who has had issues of fact adjudicated adversely to it in an equitable action may be collaterally stopped from relitigating the same issues before a jury in a subsequent legal action brought against it by a new party. The respondent brought this stockholders' class action against the petitioners in the federal district court. The complaint alleged that the petitioners, Parklane Hosiery Co. Inc., Parklane, and 13 of its officers, directors, and stockholders had issued a materially false and misleading proxy statement in connection with the merger. The proxy statement, according to the complaint, had violated a bunch of sections of the SEC as amended, and I think these are additional citations, as well as various rules and regulations promulgated by the SEC. The complaint sought damages, rescission of the merger, and recovery of costs. Before this action came to trial, the SEC filed suit against the same defendants in the federal district court, alleging that the proxy statement that had been issued by Parklane was materially false and misleading in essentially the same respects as those that had been alleged in the respondent's complaint. Injunctive relief was requested. After a 4-day trial, the district court found that the proxy statement was materially false and misleading in the respects alleged and entered a declaratory judgment to that effect. So I think this is the prior adjudication, right? Before this action came to trial. So this is the prior adjudication. Procedural context. The Court of Appeals for the Second Circuit affirmed this judgment. The respondent in the present case then moved for a partial summary judgment against the petitioners, asserting that the petitioners were collectively stopped from litigating the issues that had been resolved against them in the action brought by the SEC. The district court denied the motion on the grounds that such an application of collateral estoppel would deny the petitioners their Seventh Amendment right to a jury trial. The Court of Appeals for the second, so this is now the present case. They're trying to bring a partial summary judgment for collaterally stopping the SEC from bringing the same case. And the issue is on the SEC's right to a jury trial, kind of at the appeal level, which reversed, holding that a party who has had issues of fact determined against him after a full and fair opportunity to litigate in a non-jury trial is collaterally stopped from obtaining a subsequent jury trial on the same issues of fact. The appellate court concluded that the Seventh Amendment preserves the right to jury trial only with respect to issues of fact, and once those issues have been fully and fairly adjudicated in a prior proceeding, nothing remains for trial, either with or without a jury, because of an inter-circuit conflict. We grant certiorari. Part 1, the threshold question to be considered is whether, quite apart from the right to a jury trial under the Seventh Amendment, the petitioners can be precluded from relitigating facts resolved adversely to them in a prior equitable proceeding with another party under the general law of collateral estoppel. Specifically, we must determine whether a litigant who is not a party to a prior judgment may nevertheless use that judgment offensively to prevent a defendant from relitigating issues resolved in an earlier proceeding. Part A, collateral estoppel, like the doctrine of res judicata, has the dual purpose of protecting litigants from the burden of relitigating an identical issue with the same party or his privy, and the end of promoting judicial economy by preventing needless litigation. Blonder Tongue Laboratories, Inc. versus University of Illinois Foundation. Citation. Until relatively recently, however, the scope of collateral estoppel was limited by the doctrine of mutuality of parties. Under this mutuality doctrine, neither party could use a prior judgment as an estoppel against the other unless both parties were bound by the judgment, based on the premise that it is somehow unfair to allow a party to use a prior judgment when he himself would not be so bound. The mutuality requirement provided a party who had litigated and lost in a previous action an opportunity to relitigate identical issues with new parties. By failing to recognize the obvious difference in position between a party who has never litigated an issue and one who has fully litigated and lost, the mutuality requirement was criticized almost from its inception. Recognizing the validity of this criticism, the court in Blonder Tongue Laboratories, Inc. versus University of Illinois Foundation abandoned the mutuality requirement, at least in cases where a patentee seeks to relitigate the validity of a patent after a federal court in a previous lawsuit has already declared it invalid. Relitigate the validity of a patent that was invalid. Okay, the broader question before the court, however, was whether it is any longer tenable to afford a litigant more than one full and fair opportunity for judicial resolution of the same issue. The court strongly suggested a negative answer to that question. In any lawsuit where a defendant, because of the mutuality principle, is forced to present a complete defense on the merits of the claim which the plaintiff has fully litigated and lost in a prior action, there is an arguable misallocation of resources. To the extent the defendant in the second suit may not win by asserting without contradiction that the plaintiff had fully and fairly but unsuccessfully litigated the same claim in a prior suit, the defendant's time and money are diverted from alternate uses, productive or otherwise, to relitigation of a decided issue. And still assuming that the issue was resolved correctly in the first suit, there is reason to be concerned about the plaintiff's allocation of resources. Permitting repeated litigation on the same issue as long as the supply of unrelated defendants holds out reflects either the aura of a gaming table or a lack of discipline and an uninterestedness of the part of the lower courts. Hardly a worthy or wise basis for fashioning rules of procedure, and they're quoting Caro Test Manufacturing versus CO2 Co. Although neither judges the parties nor the adversary system performs perfectly, in all cases, the requirement of determining whether the party against whom an estoppel is asserted had a full and fair opportunity to relitigate is a most significant safeguard. So I'm going to talk out loud as I try to understand if this applies differently to plaintiffs that win, lose, or defendants that win and lose, because it sounds like it does. So permitting repeated litigation of the same issue as long as the supply of unrelated defendants holds out. So I guess a losing plaintiff wants to bring an action against a new defendant. Is kind of what was discussed there. By failing to recognize the obvious difference in a position, a party who has never litigated an issue and one who has fully litigated and lost, the mutuality requirement was criticized almost from inception, where a patentee seeks to relitigate the validity of a patent. Litigate. Okay. Interesting. So the Blonder Tongue case involved defensive use of, defensive and offensive. I don't know what is the difference between defensive and offensive. This is defensive use of collateral estoppel because the plaintiff lost and is pursuing another defendant. In other words, offensive is what's happening in this case. And offensive means specifically, we must determine whether a litigant who is not a party of a prior judgment may nevertheless use its judgment offensively to prevent a defendant from relitigating issues resolved in an earlier proceeding. So offensively to prevent a defendant. So the defendant is, yes, the defendant. Okay, so Parklane lost. They're the defendant. They lost in the prior action. Sure must be the SEC, let's just say. And so they're trying to offensively get a partial summary judgment from having against precluding the SEC from finding them guilty again. So when the defendant loses, I should use a different pen here, but the defendant who loses wants to use it, wants to preclude a new, so that's offensive. Offensive, preclude new plaintiff. Defensive, somehow as the losing plaintiff against a new. I think maybe I go backwards. Anyway, the Blonderton case involved defensive use of collateral estoppel. Plaintiff was stopped from asserting a claim that the plaintiff had previously litigated and lost against another defendant. The present case, by contrast, involves offensive use. Oh my God, it's right here. A plaintiff. Okay, the Blonderton case involved defensive use of collateral estoppel. A plaintiff was stopped from asserting a claim that the plaintiff had previously litigated and lost against another defendant. That's defensive. Loss, bringing against another defendant. The present case, by contrast, involves offensive use of collateral estoppel. The plaintiff is seeking to stop a defendant from relitigating the issues of the defendant previously litigated and lost against another plaintiff. Okay. In both the offensive and defensive use situations, the party against whom estoppel is asserted has litigated and lost in an earlier action. Nevertheless, several reasons have been advanced why the two situations should be treated differently. First, offensive use of collateral estoppel does not promote judicial economy in the same manner as defensive use does. Defensive use of collateral estoppel precludes a plaintiff from litigating identical issues merely by switching adversaries. Thus, defensive collateral estoppel gives a plaintiff a strong incentive to join all potential defendants in the first action if possible. Offensive use of collateral estoppel, on the other hand, creates precisely the opposite incentive, since the plaintiff will be able to rely on a previous judgment against the defendant, but will not be bound by that judgment if the defendant wins. The plaintiff has every incentive to adopt a wait-and-see attitude in the hope that the first action by another plaintiff will result in a favorable judgment. Thus, offensive use of collateral estoppel will likely increase rather than decrease the total amount of litigation, since potential plaintiffs will have everything to gain and nothing to lose by intervening in the first action. Food for thought. As the court goes through these arguments against permitting offensive collateral estoppel, be sure to understand them and to determine whether you find the arguments persuasive. Put down. Next paragraph. A second argument against offensive use of collateral estoppel. facts. We got the first argument is about resources. Misallocation of resources. So this is first argument. Second argument is that it may be unfair to a defendant. If a defendant in the first action is sued for small or nominal damages, he may have little incentive to defend vigorously, particularly in future suits are not foreseeable. The Evergreens versus Noonan, Burner versus British Commonwealth Pack Airlines. Application of offensive collateral estoppel denied where a defendant did not appeal an adverse judgment awarding damages of $35,000 and the defendant was later sued for over $7 million. Allowing offensive collateral estoppel may also be unfair to a defendant in the judgment if the judgment relied upon its basis for the estoppel is itself inconsistent with one or more previous judgments in favor of the defendant. Still another situation where it might be unfair to apply offensive estoppel is where the second action affords the defendant procedural opportunities unavailable in the first action that could readily cause a different result. We've concluded that the preferable approach for dealing with these problems in the federal courts is not to preclude the use of offensive collateral estoppel, but to grant trial courts broad discretion to determine when it should be applied. The general rule should be that in cases where a plaintiff, so we're making up new rules, where a plaintiff could easily have joined in the earlier action and where either for the reasons discussed above or for other reasons application of offensive estoppel would be unfair to a defendant, a trial judge should not allow the use of offensive collateral estoppel. In the present case, however, none of the circumstances that might justify reluctance to allow the offensive use of collateral estoppel is present. The application of offensive collateral estoppel will not here reward a private plaintiff who could have joined in previous actions since the respondent probably could not have joined in the injunctive action brought by the SEC even had he so desired. Similarly, there is no unfairness to the petitioners in applying offensive collateral estoppel in this case. First, in light of the serious allegations made in the SEC's complaint against the petitioners, as well as the foreseeability of subsequent private suits that typically follow successful government judgment, the petitioners had every incentive to litigate the SEC lawsuit fully and vigorously. Second, the judgment in the SEC action not inconsistent with any previous decision. Finally, there will, in the response action, be no procedural opportunities available to the petitioners that were unavailable in the first action of a kind that might be likely to cause a different result. We conclude, therefore, that none of the considerations that would justify a refusal to allow the use of offensive collateral estoppel is present in this case. So that's our holding here. Since the petitioners received a full and fair opportunity to litigate their claims in the SEC action, the contemporary law of collateral estoppel leads inescapably to the conclusion that petitioners are collaterally estopped from litigating the question on whether a proxy statement was materially false and misleading. The question that remains is whether, notwithstanding the law of collateral estoppel, the use of offensive collateral estoppel in this case would violate petitioner's Seventh Amendment right to a jury trial. So that's the new issue in the present case. To thrust the Seventh Amendment was the thrust of it was to preserve the right to jury trial as existed in 1791 Curtis v. Lowther. At common law, a litigant was not entitled to have a jury determine issues that had been previously adjudicated by a chancellor in equity. Recognition of that equitable determination could have collateral estoppel effect in a subsequent legal action was the major premise of this court's decision in Beacon Theaters v. Westover. It is thus clear that the court in the Beacon Theaters case thought that if an issue common to both legal and equitable claims was first determined by a judge, relitigation of the issue before a jury might be foreclosed by a res judicata or collateral estoppel. Both the premise of Beacon Theaters and the fact that it enunciated no more than a general prudential rule that confirmed the court's decision in Catchin v. Landy. In that case, the court recognized that an equitable determination can have collateral estoppel effect in a subsequent legal action, and that this estoppel does not violate the Seventh Amendment. Part B. Despite the strong support that may be to be found both in history and in the recent decisional law of the court for the proposition that equitable determination can have collateral estoppel effect in a subsequent legal action, the petitioners argue that application of collateral estoppel in this case would nevertheless violate their Seventh Amendment right to a jury trial. The petitioners contend that since the scope of the amendment must be determined by reference to the common law as it existed in 1791, and since the common law permitted collateral estoppel only where there was mutuality of parties, collateral estoppel cannot constitutionally be applied when such mutuality is absent. The petitioners have advanced no persuasive reason, however, why the meaning of the Seventh Amendment should depend on whether or not mutuality of the parties is present. A litigant who has lost because of adverse factual findings in an equity action is equally deprived of a jury trial whether he is stopped from relitigating the factual issues against the same party or a new party. In either case, the party against whom estoppel is asserted has litigated questions of fact and has had the facts determined against him in an earlier proceeding. In either case, there is no further fact-finding function for the jury to perform since the common factual issues have been resolved in the previous action. The Seventh Amendment has never been interpreted in the rigid manner advocated by the petitioners. On the contrary, many procedural devices developed since 1791 that have diminished the civil jury's historic domain have been found not to be inconsistent with the Seventh Amendment. Galloway versus United States. Directed verdict does not violate the Seventh Amendment. Gasoline Products Co. versus Camplin Refinery Company Retrial Limited to questions of damages does not violate the Seventh Amendment, even though there was no practice at common law for setting aside a verdict in part. Fidelity and Deposit Co. versus U.S. Summary judgment does not violate the Seventh Amendment. The Galloway case is particularly instructive. There, the party against whom a directed verdict had been entered argued that the procedure was unconstitutional under the Seventh Amendment. In rejecting this claim, the court said the amendment did not bind the federal courts to the exact procedural incidents or details of jury trial according to the common law in 1791, any more than it tied them to the common law system of pleading or the specific rules of evidence then prevailing. Nor were the rules of the common law then prevalent, including those relating to the procedure by which the law regulated the jury's role of questioning questions of fact, crystallized in a fixed and immutable system. The more logical conclusion, we think, and the one which both history and the more previous decisions here support, is that the amendment was designed to preserve the basic institution of jury trial in only its most fundamental elements, not the great mass of procedural forms and details varying even then so widely among common law jurisdictions. The law of collateral estoppel, like the law of other procedural areas defining the scope of the jury's function, has evolved since 1791. Under the rationale of the Galloway case, these developments are not repugnant to the Seventh Amendment simply for the reason that they did not exist in 1791. Thus, if, as we have held, the law of collateral estoppel forecloses the petitioners from relitigating the factual issues determined against them in the SEC action, nothing in the Seventh Amendment dictates a different result, even though, because of lack of mutuality, there would have been no collateral estoppel in 1791. The judgment of the Court of Appeals is affirmed. And Rehnquist dissents in a few pages, but I don't have the time to read that right now.